Hey, welcome everybody to Hendry and Parker Legal Briefs. These are podcast shorts that we are putting together to hopefully go over some basic surface items of questions that people often ask us about.
Yes, and we've gone over a lot of different areas of the law just to kind of give you a taste of where things are, where they stand, and what you might expect in a legal situation. Today, we're going to talk a little bit about the statute of limitations in criminal cases.
I've had someone ask me recently about a statute of limitations.
I think I saw that in New York last
Yeah,
time I was
yeah,
there.
I think it's over on Washington. But
Yeah.
no, there's no statutes of limitation. It's a statute of limitation, and it's a very fancy term of basically saying how long you have to charge someone or to sue someone over an incident. So there's a time when will start tolling, and then when that time ends, you no longer have the right for legal action in a certain case.
Right.
To put basically.
Yeah, and in a criminal case, essentially what that means is from the time that you are alleged to have committed an offense, the state has so long in which to bring forward a prosecution, in which to arrest you, file charges, whatever. But they have a certain period of time. If it's a misdemeanor, a less serious charge, a second-degree misdemeanor is the least serious criminal offense that's punishable by up to 60 days in jail and a fine or 6 months of probation. In that case, the state has 1 year from the date of the offense to when they can bring forth charges or arrest you.
Can you give us a couple of examples of a second-degree misdemeanor? I mean, these are the least serious crimes you could commit.
A driving on a suspended license in many situations is a second-degree misdemeanor. Another second-degree misdemeanor is a disorderly conduct, where you may be a little bit drunk or just acting stupid. You raise your voice, you get a little bit out of control, and the police arrest you for that. So those are a couple examples of second-degree misdemeanors.
Yeah, so very non-serious things, but the state has 1 year to charge you for those.
Right.
But those aren't the ones that typically you're worried about. Now let's talk a little bit about first-degree misdemeanors. This would be something like a DUI.
A DUI, a domestic battery, a violation of an injunction, a petty theft over a certain amount of money is a first-degree misdemeanor. Now, these crimes are punishable by up to a year in the county jail, and you can be subject to probation for up to a year as well. In those situations, the state has 2 years from the date of the offense to bring forth a prosecution.
So it's possible that you could be there could be a battery alleged that you committed. Say it's a bar fight, and 1 year and 364 days later, the police come to your door and arrest you on a warrant.
Looks like you're out of luck, and they complied with the statute of limitations by 1 day.
But while that may be possible,
right,
it's very rare to happen. And the reasoning is a case has to be pretty ripe in order for the state to want to charge you with it. The evidence has to be somewhat fresh, and then for them to do something like that 2 years later usually doesn't happen because the evidence has kind of dried up in that case. It happened so long ago. Does anyone really care? Because if that case were to go to trial, that might be another year down the road. And
right.
This case will be 3 years old. And if a jury's hearing about things that happened 3 years ago, how interested are they going to be anyway? So the state usually doesn't do this. It would be a terrible tactic if they did.
Right, and it's very difficult for the person charged with that crime to adequately defend themselves for something that happened 2, 3, 4 years before. Memories fade, witnesses disappear, so you may find yourself in a real disadvantage if you have to defend yourself against a not so serious crime 3 years after the fact. And that's why the statute of limitations exists.
And that's a good transition into felony statute of limitations, because there are situations in which the state really didn't have an opportunity to charge someone until way later after the event, and that's why the statute of limitation grows for felony charges. Now, what is the statute of limitation for a third-degree felony, which is the least serious felony that you can commit?
Right. For a third-degree felony, which is a crime punishable by up to 5 years in prison, or a second-degree felony, which is a crime punishable by up to 15 years in prison, the state has 3 years to bring forth the prosecution from the time of the offense.
Okay, but if the state might have found out that something had happened later on. Say a witness comes forward 3 years later and states that she was um, assaulted. It's an aggravated assault. Someone pulled a knife on her 3 years ago or 2 years ago, and she didn't come forward. She's having a lot of mental distress about it. She comes to the police. Could they effectively get a warrant and make an arrest on that charge?
Well, in most situations, no. But again, if that person comes forward and the state attorney is able to put together the evidence, or if the police believe they can make an arrest, and it's 2 years and 363 days, well, then unfortunately the statute of limitations hasn't been brought into issue, and you will have to stand and face the charge that you've been arrested for.
But to keep in mind, the case is probably not ripe. The evidence is
Right.
probably old. It's it's a tough case to prove.
It it
So they
it
don't normally do
it
that.
becomes more difficult. And then on first degree felonies,
The most serious of all.
the most serious, well, there are capital felonies, but there are no statute of limitations for capital felonies,
What's
which is
capital felony?
capital felony means something punishable by, it used to be death. It still is death. There's a possibility of death in a capital felony murder. There's also a capital sexual battery, which is obviously a very serious offense for which you can face life in prison. But if there's not a dead body, then there is no possibility of a death penalty.
Very important to know.
Yes.
No corpse, no death
No
penalty.
corpse, no death penalty. Well, or there could be a corpse that nobody finds, and I guess you could get the death penalty in that circumstance, but it's very rare.
So first degree felony, what's an example of a first degree felony?
First degree felony it could be a grand theft of over, I think it's $100,000 is a first degree felony.
What about a kidnapping?
A kidnapping it's not only is it a first degree felony, it's a life felony.
Is that a PBL they call?
Well, it's even more than a PBL. A PBL is a punishable by life. A PBL could be a home invasion robbery. It could be what's another example of a PBL?
That's not to be confused with a PBR, which is
Yes.
a Pabst Blue Ribbon.
Yes, a Pabst Blue Ribbon is far preferable to a PBL.
PBL is very serious. It means punishable by life.
Right.
That means the jury could come back with a guilty verdict, and the judge could give you life.
Right.
And they very often do after a jury trial, a unanimous verdict jury trial.
Right. So a first degree felony is the statute of limitations on a first degree felony is 4 years.
So 4 years the state has to charge you for a first degree felony. Now, what about murder or rape?
A sexual battery or a homicide, there is no statute of limitations. So you can't leave the country, come back 5 years later, and think you're good to go, because you're not.
Yeah, a lot of people want to find legal loopholes, and they think that that's what our job is to kind of, we find those loopholes to get you out of trouble and get you that get out of jail free card. Unfortunately, it's not usually that simple. There are times when statute of limitations has run out in a case, and we can take advantage of that, but it's very rare because the state usually doesn't wait several years or even a year to charge you with a crime, and they're very aware of what the statute of limitations are, and they're also very aware that the strength of their case is not very good when they wait.
Right, right. So, in a nutshell, that's statute of limitations. There are some exceptions to that. In some theft cases, the statute of limitations is extended to 5 years if the theft itself was not realized until some later point. So there are some exceptions, but as a general rule for felonies, it's 3 years if it's a first or second degree. I'm sorry, if it's a second or third degree felony, and it's a 4-year statute of limitations if it's a first degree felony.
And for the sake of time, I won't get into the weeds on this, but in personal injury cases in which you are injured in one way or another from someone else's negligence, you have 4 years from the time that you reasonably found out that that this happened. Sometimes you might not find out until later because you might get an injury later that came from that, and the injury kind of presented itself at a later point. But typically, you have 4 years to file in a personal injury case. Obviously, there are some exceptions to that rule, but that's the general rule of thumb is 4 years in a personal injury case. So that's statute of limitations. Thank you, Don, for shedding some light on that.
I appreciate it. Thank you, Chris.
And you can get a hold of us, and if you want to talk to us about a case in any way, shape, or form, including statute of limitations or not including statute of limitations, we'd be happy to talk to you. You can reach us at 727-205-5555. Our website is
HendryParker.com.
All right, we'll talk to you next time.
Thanks.